The BC government toughened its stance against the Cowichan Nation's recent Aboriginal title ruling today as concerned residents gather in Richmond for a town hall on the impact to their private property rights. For more, let's check in with Rob Shaw at the BC Legislature. Rob, tell us what the latest is from the BC government.
Well, Stacey, some pretty clear declarations from the Attorney General today that Aboriginal title cannot coexist with private property rights in their full form at the same time because both of them confer the right to occupy and use the land, so therefore they are incompatible. Nikki Sharma saying today that the BC government will fight the Cowichan Nation title victory in part using the argument that BC's private property ownership system suspends Aboriginal title when the two overlap. Now, the BC Supreme Court rejected that argument this summer. It awarded the Cowichan Nation title to 800 acres of a former village in Richmond, which is now land held by the city, the federal ports, and more than 140 private homeowners and businesses. The court said Aboriginal title is a superior title to private property. Concerned Richmond residents are trying to figure what that means. Out tonight at a town hall, Sharma said she'll go and talk to folks there, but the opposition says it is too late. The court ruling will have widespread implications even if the Cowichan case is negotiated.
The problem is this has now set up the same problem everywhere around the province. 120% of British Columbia is claimed by First Nations. This is going to be a case that's going to come to every community, that's going to come to everybody's private property, whether it is, in the next year or whether it's in the next decade or two. This will come. It needs to be resolved, and we need to be able to protect private property rights. How do you build a housing project if you don't understand what the rules are underneath the land? And so that's why this is so important.
BC did not argue in court that Aboriginal title is extinguished by private property, but the City of Richmond is making that argument, saying that a previous landmark Supreme Court of Canada ruling called Delgamuukw in 1997 is no longer good law. BC won't go quite that far, but it does say it profoundly disagrees with the idea Aboriginal title is superior to private fee simple title. It intends to fight it in court to the Court of Appeal, possibly the Supreme Court of Canada, over the coming years.
I appreciate that is one of the key concerns, though, that the interaction between Aboriginal title and the fee simple ownership and how that title is viewed with respect to that court decision in the future. And we will be tackling that question with what will be a very complicated response in terms of our legal arguments that piece through. But at the foremost of it will be the idea that once you have a fee simple title in BC, it has to mean that those boundaries of that land is your land.
The Cowichan Nation out with a statement this week accusing the BC government and Richmond of making misleading statements, saying that although it did sort of challenge the validity of the federal and city land titles, it did not go after private property in this case. It said if private property owners do suffer some type of losses, their remedy is against the provincial government, not the Cowichan Nation. But a lot of concern and a lot of debate still here at the legislature amongst lawmakers about what this means and where it is going.